So we're going to talk about, obviously, the changes to the Florida Business Corporation Act. What we're trying to do is pull in these changes into why they're important and how they can affect you, okay? So we'll go over some different aspects of the changes. This is not meant to make you a lawyer, and so we're going to touch on the top level. You should feel free if you have any questions or issues, you can raise them now, of course, but also just give us a call. We'll be happy to answer any of your detailed questions as well. This thing isn't working.
I'll point at my computer.
Nothing's working. There we go. For the second part, we'll have a little coffee break. For the second part, we'll talk about shares and equity, so ownership interest, and then we'll get into a pretty common area called appraisal rights. So we'll do that. Okay. So what's the Florida Business Corporation Act? So it's Section 607 of the Florida Statutes, and essentially it was enacted in 1989. And it hadn't really been touched since 1989. There were some minor modifications in 96 and 2003. So 30 years old, it's time to really take a look. Now, we have a statute that is based on what's called a model act. The American Bar Association has these groups that come together and provide statutes for states that they can enact in whole or they can modify it as they want. And so there's a whole slew of these different model acts. And so that model act was updated in 2014. And then our state, we have the Florida Bar, and there's a business law committee. They created a committee that would look at those and kind of correlate the two of them to come up with the changes. The benefit of having a model act is that when there are things that go on in other states, we can sometimes use the law as an example of what's gone on in other states and then what to do in Florida. The other side of it is that lawyers from other states can also understand what our laws are without necessarily having to go through that entire process, right? And so what we're doing here is we're getting an act that is really a little bit more favorable. It's a little bit more modern, and what we're doing is kind of approaching that Delaware, right? So everybody knows large public companies love to be, or are typically Delaware corporations. Yep. There's reasons for that. And so we often get the quick question, right, of, hey, well, do I do a Delaware corporation? Do I do a Florida corporation? And for the most part, if you have a closely held business that's operating in Florida, and you're just going to kind of go and do your business on a regular basis, you want to be a Florida corporation. Because if you're a Delaware corporation, you have to pay registration fees in Delaware, you have to get a registered agent in Delaware, so you have to hire somebody who does that, and then you have to do the same exact thing in Florida, because you get authorized to do business in Florida. And so that doesn't make a lot of sense. There's a lot of extra cost there, and when you're a closely held company, you're going to have a shareholders agreement or some other relationship where the statute isn't going to make a lot of difference to you. Plus, now our statute is very close to their statute anyway, so there's some benefits there. So an example of why we're doing this is because the LLC Act, so limited liability company, a little bit different than a corporation, was modified, actually really revised substantially in 2014. And I don't think a month goes by that we don't encounter a person who comes in with an LLC problem, maybe it's a partnership problem or whatever, and they have an operating agreement or some documentation that's pre-2014. And so there was no situation where we can now every LLC has to meet today's statute, just as every corporation has to meet today's corporation statute. And so when we have somebody that comes in and their documents don't match, now what we do is either we default to what the statute is, which is generally what people don't want, or as an alternative, we have to kind of figure out what maybe they meant. A good example of this is kind of the issue of managing member versus, right, that went away in 2014. So as of 2015, there was no such thing as managing member. And when you get an LLC operating agreement that comes in and says, hey, so-and-so is going to be the managing member, well, that just means that LLC is now managed by the members, not by any manager. Because you have to specifically state that your LLC is going to be managed by managers in order for it to be set up that way. The other issue that applies is withdrawal. The 2015 changes prohibited withdrawal, prohibited a limitation on withdrawal, right? So previously, you could have in your operating agreement that a member cannot withdraw. And most operating agreements that we see, especially those that come from like online document providers, say that you can't withdraw. Well, the Florida statute says you can't have that. So then they can withdraw, but we now have no provisions about how a party withdraws. These are the kinds of things that are going to happen in the corporate arena, and so we want to prevent that. Probably, you know, if you look at this, really, Florida, New York, California, and Delaware are the environments where you have these exploding numbers of LLCs and corporations. What you'll see here is we have about double the number of LLCs that we have for corporations, and that really makes sense because LLCs traditionally are these small businesses, and so we're adding 300,000 of them a year. That doesn't mean that next year we'll have 1.6 million because there's a lot that will fall out and whatnot. But again, we're 780 on the corporations, and we're adding 100,000 every year for those. So what do the changes mean? The reality is most of the time it's going to affect a multi-owner business. There are a few things, and we'll call those out, that are going to affect an individual, a business that is owned by one single person as well. Remember that what you have is not grandfathered in. So you've got to go back and look at the key documents, the articles of incorporation, the bylaws, and the shareholders agreement. Now sometimes practitioners will utilize the forms that are on Sunbiz for formation or things of that nature. It's important to remember that those forms have not been updated for these acts now. So you should not use those forms going forward. They will eventually be done, but we don't have a date on when that is.
It seems a little bizarre that they change the law and not update their online form.
Yeah, well, they're also 8 weeks behind in filing.
Yeah,
so,
I noticed that. I was going to ask about that.
Yeah, it's so, you know, I think that's probably a funding issue. There's all this activity and not enough bodies to handle the activity. So that's
It might be
my guess.
slightly a disorganization issue too, because these statutes were actually posted back in like August, and they were the default view of the statutes, even though they weren't in
effect
yet,
until January
1.
But they showed up on the data
Yeah.
on the state database as being in effect. So
Yeah.
it could be disorganization, but that also could be enough people.
Yeah, exactly.
All right, so lawyers love definitions, right? Because the idea is to make things nice and clean. We have 80 definitions in total. We used to have 31, so 49 new ones, very important. But also the 31 that were there a lot of them were modified pretty substantially. So definitions really are the key to this. Whenever you're looking at a statute or an agreement and that has definitions, what you really want to do is read the provision, notice where the definitions are, and then go back to the definitions because it gives it context. Okay? All right, so just some of the examples. We now have electronic transmission. The state allowed electronic transmission previously, now it's expressly permitted, but we've added this provision that it has to be capable of being printed by conventional means. So essentially what it means is if you're sending an electronic document, it's really got to be in PDF. That's really what it means. This is an important one. We added an issue of insolvency. So a definition of insolvency. Previously, insolvency meant that the business couldn't pay its debts as they matured in the ordinary course of business. We have now added to that what's called the balance sheet test, which means that the liabilities are more than the assets, so we'll have negative shareholder equity. Now, where this applies is in the context of doing distributions. So if you are, and this is one of the areas that applies to single member as well, if you are a director of a corporation and you want to make a distribution on an annual basis, that corporation must be solvent. If you make a distribution and the corporation is insolvent and then the creditors don't get paid, you personally are liable for the amount of that distribution, right?
And Ed, are you speaking about both corporations, CNS?
Yes,
Okay.
and that's an excellent point. So there's only, from a Florida perspective, there is one thing, and it's called a corporation. From an IRS perspective, they make the distinction between C and S, okay?
And
So-
the distribution is not just what we think of as a distribution, a dividend, it's also the redemption of stock. So if let's say you have a partner and you wanted to buy back his or her stock, that's also considered a distribution. So unless the company is solvent, has the ability to pay its debts as they come due, as more assets and liabilities, you can't buy back the stock of one of your shareholders.
So that's definitely a thing to keep in mind. We also have this concept of qualified director. I'm going to go into detail on that on conflict transactions. We also have executed versus signed. So now it's very clear that you can send an electronically signed document to the state. You don't have to sign something with a wet signature. And then we've identified other entities that can act as registered agents. So you don't have to have a person act as a registered agent for your corporation. You can have another entity. A lot of times law firms and accounting firms will act as registered agent. And now, although the state has been letting some of them, now all of these types of entities can do it. Something that's really unique now is this issue of extrinsic facts. So you can have different classes of stock in a corporation. You can have common stock and you can have preferred stock. Preferred stock can have a coupon rate or basically a return, a guaranteed return on the capital that's been invested. Now, previously you would put, okay, the return is 8%, the return is 5%. And then if the economic environment changed, that would either be good or bad, right? Because you'd be different than what the economic environment is. Now what we can do is we can say that the rate of return on preferred stock is 1 point above, 1 point below, whatever the prime rate as published in the Wall Street Journal, or LIBOR, although LIBOR is going to go away, I guess. But we can tie it to something outside of the documents. We also can do things like adjust, Susan and I, two lawyers in a room means you'll have 4 different opinions, so, right? Susan and I have a difference of opinion on this. I think what you can do is, put in a provision that allows the stock, the amount of stock to vary depending on outside conditions. And Susan's going to talk in detail about that. But that's really an interesting thing because now if you have an investor on board, you can change the percentages, you can change the dilution of the current owners, and we'll talk about that. So anyway, we can refer outside the document, very important. Effective time. We can actually now form a corporation and backdate it up to 5 days. So if you want to do a deal, or you've done a deal and, oh my God, we got to form a corporation, whatever the case, we can push that back 5 days.
But it still takes 20 days to get it.
If it was only 20 days.
Yeah, if it's 20 days. So it used to be, we could file it, it would be effective the same day. I mean,
Right.
Yeah,
Yeah,
That's a
that
problem.
I did one years ago, it was 24 hours, it was shown in Sundance.
that's right. And now 8 weeks, which is horrible.
You get a little notice though that says we won't be able to do this.
If you use a filing service, does that help to walk it through?
It may, it may. I mean, I can't imagine there's not a way to walk it through, that there's not an amount of money you can pay to have that done, but I'm not positive about that.
So Delaware specifically states, you pay us this fee and you will get counter service. We'll do it right then and there. Florida does not have that option. So there's no guarantee, even if you bring it to the front desk, that they're going to do it right then and there as well. Standards of knowledge, very, very important, even for single member, or single shareholder corporations. So in the prior statute, we had knowing, which was actual knowledge, and now we have this kind of should have known, I swatch it. Having actual knowledge was the standard. So actual knowledge does not mean constructive. There's actual knowledge, there's constructive knowledge. Actual knowledge is I in fact know something. Constructive knowledge, on the other hand, means that I effectively should have known something because it's in the public record, or one of my subordinates knew something, right? Something along those lines. So that's the issue here, is now we have this potential risk of should have known. So as an owner, director of a corporation, you really have to make yourself aware of material facts and think back to the distribution issue. you've got to know what's going on financially before you make that distribution. And then certainly if it's a multi-owner corporation and you have shareholders that are different than the directors, the shareholder standards, the director standard now is you've got to make those inquiries. Okay, so pre-formation contracts. This is also important, for example, in the buying a business context, right? A lot of times what will happen is the buyer will come and put together a contract and they'll submit it, and they'll submit it in their name, and then the provision of the BBF has a contract that specifically says, oh, and then the buyer can assign it, da-da-da. Well, we get involved in situations where we have to do an assignment document, and so it's extra documentation. So what can happen now is it can be the contract can be formed in the name of the corporation, and then we can go back and form the corporation later. Now, of course, the corporation has to adopt the contract as its own and has to do it. But even though the buyer and the seller in that case don't know that the corporation does not exist, that contract is still valid and binding on the corporation.
What I'll typically do is, if you're signing it, let's say you're gonna buy a business and you're starting a new company to do that, buy XYZ Inc., a to-be-formed Florida corporation. So that kind of eliminates the need even to assign it from the individual, and it also, in my mind, sort of mitigates some liability that the individual might have. So you're always signing it in the name of the corporation. And the new statute changed a little bit, so now that the company actually has to ratify that agreement, which makes sense.
Yeah, so, and that's a simple thing, it's just, we accept, agree to be bound. So sometimes what we have in these types of agreements where there's multiple owners is we set up different classes so that one class can elect one director, different class can elect a different director, right? So everybody's represented at the table. Now, previously, you could do a shareholder action by written consent. You didn't have to have a meeting. You could just sign documents to make it happen. And as long as a majority of a class agreed that that person was going to be the director, you had it. Now it has to be everybody in the class. It's got to be unanimous. Otherwise, it's ineffective. Standards for directors. So this applies for all corporations, right? You think, well, if there's only one director, one shareholder, and one officer, why do we care? Well, we care because if a creditor comes in, right, isn't paid, they have the right to essentially take over the corporation, and then they stand in the position of how the shareholders would have stand. So if the director did something improperly, the creditor can enforce it against the director, right? And essentially you're taking money out of the corporation that should go to the creditor, and so now the creditor can go directly to the individual and collect that money back from themselves. So the standards are very important. All right? We have good faith and best interest of the corporation. The key here, best interest of the corporation, and we want to think about arm's length transactions, things of that nature. This is the business judgment rule, so the prudency, right? Essentially understanding the deal, not just jumping in heads first. And then reliance. Who are you allowed to rely on? Because as a director, you don't necessarily know all of the facts. And so this set up a standard where you as a director have the right to rely on lawyers, on accountants, on employees in your organization who have the right to control this particular area. And you have that right to rely unless you know of something that tells you not to rely. So if you know that the person's incompetent or that it's not their area of expertise, you can't rely on it. So what you want to be thinking about here is kind of the end run situation, right? And so I can't make myself blind to circumstances that make me question the information I'm getting. I can't accept that information blindly if I know that there's something just not quite right. New section, previously if a corporation had a director and you had a situation where that director was appointed, so typically what you have is a majority-minority setup. So one person owns the majority of the stock, the other person owns the minority. The majority owner appoints himself or herself as the sole director and then proceeds to loot the corporation, right? And so this new section protects now against that because you can petition a court and the court can remove the director. Previously, they couldn't remove the director. The only remedy was to get a court-appointed receiver to take over the corporation. So now you can do that. Again, gross abuse of power, fraudulent activity, things that are pretty severe. The court is not going to come in and make second guesses on business things, right? So as long as prudence is shown, they're not going to come in and say, well, you get removed because you were wrong about this business decision. But if you are taking all of the assets out the back door, that's a good case for removal.
Or taking all the profit out in salary and distributions.
That's a questionable area, right? Well, distributions, you'd have to have distributions according to percentage ownership, right? But if you're buying yourself a Lamborghini and, paying yourself everything and there's none left, I think you might have a case under that.
But somebody's got to complain, right? So there has to be some kind of shareholder dispute, or the company can't pay its creditors, and then a creditor is sitting in the place of a shareholder complaining that you bought a Lamborghini with the money you should have paid me for the copy machine.
Yeah.
So the director's language here applies to all entities, all forms of entities?
Just corporation here.
Just the C Corp?
Well, C Corp, S Corp, but it's for us, it's just a Florida corp.
So
So C Corp or S Corp, therefore.
Yes.
as Ed said, under all corporate law, Florida law, Delaware law, it doesn't distinguish between C Corps and S Corps. That's an IRS thing. So a corporation is a corporation, and I mean, if you wanted to get really complicated, an LLC actually can elect to be taxed as a corporation. But a corporation is just a corporation. It doesn't matter if it's a C or an S Corp.
So I'm gonna ask a kind of a dumb question.
Never.
Why would anybody wanna be a corporation when they could be an LLC?
So it depends on, my distinction, right, is if you're going to be a closely held business and there's no other reason than, and multi-member, you want to be an LLC, right? So closely held business, multi-owner, you want to be an LLC. If there is another reason, depending on who the shareholders are, depending on, if you're going to get outside investment, various different things, then you would pick the corporate
Like if you think
form.
you're gonna be a Coca-Cola in the future or something and do an IPO or something like that?
But even that, I would start you out as an LLC and I would convert you into a corporation.
Okay.
To Ed's point, typically professional investors, venture capitalists, private equity type people that are investing in your business, they still prefer to see a regular C corporation. So a corporation does not make an S election, profits and losses stay with the corporation. They have documents to facilitate those kinds of investments, and an LLC gets too complicated for them.
The other issue is you got to look at what the future prospects are. What are you going to do and when are you going to do it? Because if you're pretty sure you're going to be getting outside investment, you want to be a C corporation from day one. Because when you flip from S to C, if you have losses, those losses could be suspended and you could never realize them until the company is ultimately sold. So it's a super complicated tax question if you're going to get investment and when really those are the two variables. Am I going to get investment? When am I going to get investment? The other question is, in some cases, you have to be a C corporation, right? It depends on, if you're using money from a retirement plan or things of that nature. You must be a C corporation. Now, the negative to a C corporation when you sell is obviously you have double taxation. So, right, the C corporation gets taxed on the sale transaction, and then when the money is distributed to the shareholders, they get taxed as well. It's a little bit better than it was in the past because of the Tax 2016 Tax Cuts and Jobs Act, because there's now a flat rate, effectively a flat rate on corporate tax of 21%. Okay, so applicable county, forum selection clauses. So we're going to get into those, but if you have this going on, the forum selection clause that is in your articles will apply. Okay, conflict of interest. So previously there was a lot of language in the statute. It wasn't super clear. This has clarified it quite a bit. The issue is, when does a director have a conflict? And you think any time that there could be this impairment of objectivity on behalf of the director. So the director has a material financial interest, a family member of the director has a material financial interest, something along those lines. So the question always is the transaction fair to the corporation? And when we talk about that, basically we're talking about arm's length. So if the interested director was not involved, would the same deal be offered to the corporation, arm's length transaction? And so, think about it. If I'm selling the three of us are shareholders in a corporation. This always happens too in my office. I'm on the phone and the lawn guy comes by. So the three of us are shareholders in a corporation. I have a piece of property that I want to sell to the corporation, right? So now I have a conflict because clearly I want to sell it for the maximum amount of money I possibly can. So I then become that conflicted director. And in order to determine that, we want to say, is Ed selling it at fair market value? If Ed was not a director, would the corporation buy it on the same terms, same conditions as they're buying it now? That would be fair to the corporation. Okay? So when we have this conflict of interest transaction, what has to happen then is I first have to disclose it to my fellow board members, and then they have to approve it. It has to be approved by the qualified directors. So the qualified directors are those who have no interest in the transaction. No interest in the transaction. And now, what happens if Susan and I own the land and Nick does not? Well, Nick can't approve it as one director, right? So we have to have more than one director, and a majority of those remaining directors have to approve it. But if we only have one, then we have to turn to the shareholders. And we have to turn to the majority of the shareholders who are not interested in the transaction. So essentially what we're trying to do is cleanse the transaction of my influence. Now I can vote as a director, and my vote can be counted, it just can't be the determining vote that's going on. All right, so what happens, we do the deal, and then somebody complains. They say, that wasn't fair, right? No matter what you think, that wasn't fair. So what happens here? Well, if we follow these rules, then the person who complains has the burden of proof of showing that the transaction was fair to the corporation. If we don't follow the rules and a person complains, we have the burden of proof of showing that it was fair. In other words, if we don't follow the rules, it doesn't mean that, per se, it's unfair. We can still show that it's unfair, but now we have to show, fair. We have to show that it's fair. Make sense? Okay, so standards for officers should look very similar to the standards for directors, right? So good faith, best interest of the corporation, prudency, and then reliance. Same kinds of things. We have one additional aspect, and again, if you think about this in kind of the Enron context, that is, if I know of something, I have a duty to report it out. So I have to report it to the CEO, we have to report it to the chairman of the board, so that there is this flow of information. Nobody can say, hey, I didn't know. Okay? And that's really what it amounts to. So actual or probable material violation of law, or things that I should know. I can't make myself actively blind to things I should know. All right, so indemnification, another area that's super important. So indemnification is like an insurance policy, except we're using the assets of the corporation to pay expenses. So if I get sued by virtue of being a director or an officer of the corporation, okay. Now, that's because I stopped, they stopped. There.
Right.
If I get sued because I'm an officer or director of the corporation, then what happens is I want the corporation to step in and to indemnify me. So, right now, I'm entitled to that. There is a mandatory indemnification, and then there's permissible indemnification. So from the mandatory standpoint, if it turns out that I am right, that I am essentially acquitted, there's no liability on my part, then the corporation will come in and pay the expenses that I had. But that isn't really a remedy, because what happens if I don't have the money to pay the lawyer, or I don't want to pay the lawyer, I want the corporation to pay the lawyer? So there's this concept of advancing the expenses. And so essentially, indemnification is the corporation standing as an insurance company to me, and in the process, do they defend me, or do I have to take care of it myself? Now, we used to have this for employees and agents, as well as officers and directors. And we now don't have it for employees and agents. Now, the law of agency has a provision about when companies have to protect their employees and their agents. And so we're just relying on that. That goes back to that. But for officers and directors, we really, I mean, if you think good faith, best interest of the corporation, we add this one provision in here, no reason to think that the actions were unlawful. Okay? Now, advancement of expenses, this is something that we want to put in a shareholders agreement, but essentially, the corporation can advance the expenses if the officer agrees to repay. In other words, if it turns out that I wasn't entitled to indemnification because I did something wrong, I have to write a check back to the corporation for those expenses. Now, the thing about this is the board of directors can make that decision at the time of the lawsuit. And so if we don't want to have that, we want to have an indemnification provision in the articles, and we want to have indemnification provision in the bylaws, and we want to have it in the shareholders agreement as well. Okay? When they agree to repay, it has to be unlimited. They can't say, I'll just pay back $30,000 or something like that. And then really, it really needs to be in the shareholders agreement, because as a director, you don't want liability, you don't want the question of whether you're going to be protected to be determined at the time of the lawsuit. You want to know it early on.
And would that be in the term of a loan document or just an indemnification document?
It's an indemnification provision
Provision,
in the articles or the bylaws, or I believe the best place is in the shareholders agreement.
The other thing is, under Florida law, if in your articles, which I think you'll see a lot, it says the corporation shall indemnify its officers and directors to the full extent of Florida law, it also then by definition means not only will it indemnify its officers and directors, it will advance expenses.
Okay, so form selection. So what is form selection? Form selection is the ability to determine where a fight happens in advance of the fight. And so your articles of incorporation would typically have a form selection clause, and it would look like something like any disputes regarding the internal affairs of the corporation shall be undertaken in the location of the principal office of the corporation. So if you're located in Orange County, you're there in Orange County. Question becomes whether you want to do that if you're located in an area that isn't really a commercial commerce center. So, if you happen to be in, I don't know, Sumter County, right? Do you really want to?
Are you casting dispersion?
I wasn't not casting dispersions. It's not a commercial center, to say the least, right? So you want to be careful about where you select. You want to be thoughtful about that. And then, if for whatever reason you move, right? So you have a business in Orange County, you select Orange County, and then you move to Tampa. Well, now we got to go back and take a look at the documents and make sure that's there. So then we have fee shifting provisions. So fee shifting provisions are keep people honest provisions, right? Because they make the loser pay the winner's attorney's fees, right? And so what that does is it makes you think twice before you bring a lawsuit, because if there's low likelihood of winning, you could be on the hook for more than you're going to get out of the deal. So we recommend fee shifting provisions. Now, it used to be that you could have them in your articles and your bylaws, but you cannot any longer. So again, another reason why you want to have a shareholders agreement in there as well. Entity names changed too. And so now, it used to be that they had to be distinguishable. So you couldn't have ABC of FL, ABC of FLA, ABC of Florida. Those were too close together, and the state wouldn't allow it. Now, however, you can do that if you have permission of the first entity that filed. So where would we use this? In a holding company subsidiary setup. So if you have different operating branches, they can operate under nearly the same name, and you can distinguish it that way. So you do have to have the consent. It's important to note that this does not apply to fictitious names. So if you're operating a fictitious name, you can operate under the same name across various locations. Having said that, it's a little bit dangerous to do that if they're all located close together, because you could get a lawsuit filed against multiple entities, and the whole idea of setting up that holding company is to avoid lawsuits against multiple entities. We used to have, and now we have back, this name reservation. So you can hold a name for 120 days. There isn't a lot of, I guess, excitement over this. I don't know that it necessarily is going to be used all that much. We could use it in the business purchase context, because you could reserve the name as you go out and start looking for a business, and then just form the entity when you find it. At times, what people run into is they'll form an entity, and they won't realize that by forming it, they actually have to file their tax return, even if it's a zero tax return. So it is transferable, which is nice. And then remember that trademark law still applies. So I can't go out and form a corporation, Nike, and go begin manufacturing and selling sneakers. That is it.
Yeah, so even if there's not a Nike Inc. in Florida, if you start selling sneakers under the name Nike, Nike's going to send you a letter.
Cease and desist.
Mm-hmm.
That won't be a nice letter. So authorized entity, so we specifically added limited partnerships, limited liability partnerships, and limited liability partnerships. Yeah, so those can all be the subject of conversion. They can be registered agents. They can be all those things. Okay, registered agent now, in terms of resignation, is a little bit different process. You still have to file a document with the Secretary of State, but then you also have to transmit a notice to the corporation. So if you are a lawyer and accountant and you're a registered agent for a client, you have to let them know. The filing isn't effective until the 31st day after you send notice to the corporation. And then if the corporation fails to immediately appoint a new registered agent, then they can't maintain or defend an action in Florida. So they could, at least in theory, be subject to a default. And they can be subject to a penalty of $5 a day up to $500. So good idea to get maintain that registered agent. And so service of process, there was a number of different statutes that applied. So this was clarification. You always have to try the registered agent first, then you move to the chair of the board, then you move to the president, then you move down the line. If you don't get anybody, now you can serve the Secretary of State, and that's valid service. But it's not exclusive.
Yeah, I had an insurance company client not so long ago, and by Florida law, you have to serve the Commissioner of Insurance. So if it's a regulated industry, I mean, that's the moral to that story, is regulated industries sometimes have odd rules, and you got to check them.
Okay, so bylaws, we did a CLE, so continuing legal education program for obviously lawyers, so went in pretty in depth. It was a whole day program. And, one of the things that they pointed out to us is you absolutely have to go through bylaws and re-examine what's in the bylaws, because so many things have changed that most of the bylaws are going to be out of date. So we can't have fee shifting provisions. So if they're in there, they will not be applicable. And we are allowed, though, to have that form selection, so it should be in there. We have two new things that probably should be added, and that's electronic notice to the directors of a meeting. So you can send an email now. If it's in your bylaws, you can send an email to the directors, and that will suffice. So no more having to send, written correspondence to directors. And then we have remote participation for both directors and for shareholders at shareholder meetings. Now, there are some restrictions here because the people that are appearing remotely would need to be able to hear and to participate with everybody else in the session. So it's not, depending on how many shareholders there are, it may not necessarily just be getting everybody on a Skype or Zoom session or something like that. And in the bylaws, you definitely want to have a provision that says it's commercially available and have the corporation have to pay for that access, right? Because to set up Zoom, you typically would need to have an account, and there's some charge for that. But if you're a participant, you don't have to pay.
One thing that didn't change is directors, there's two ways directors can act. They can have a meeting where there's notice and people get together and vote, or they can act by written consent. But you can never have less than unanimous written consent. So if you're gonna have if you have 3 or 4 directors and you wanna take an action in writing, all 4 directors have to sign. Whereas if you have a meeting, a majority would rule, unless the bylaws say otherwise.
And that, there's another thing that comes up around directors, and that is, can directors act by proxy? I get that question all the time, and absolutely not. They cannot act by proxy. So. Okay, so subscription agreements. So we're going to form a corporation. We have 2 partners, and the partners agree that they're going to put in money in exchange for stock. So we have a, right? So they agree. Is that enforceable? It's not enforceable unless it's writing and it's signed by the subscribers. So very important to put in there. One of the things you want to add to your articles is kind of the opposite provision. So it's only enforceable against the subscriber if it's in writing and signed, but it may not be only enforceable against a corporation in that case. So we want to put in the articles that it is enforceable. Interesting, the statute used to say before incorporation, and now it's been added after incorporation as well. So in terms of that, now again, enforceable after incorporation. So kind of the voting agreements and the shareholders agreement, there used to be in the statute, voting agreements were called shareholders agreements, and shareholders agreements were called shareholders agreements, and nobody knew kind of the difference between the two, so we specifically now call voting agreements voting agreements. And that is literally an agreement to vote shares. So Susan and I can agree to vote our shares a particular way, and once we agree to it and we sign off on it, we're bound to that agreement. And we cannot vote the other way. And if we do, then a court can come in and tell us, no, you have to vote according to that agreement. Interestingly enough, there's no requirement that Susan and I notify the corporation that we have an agreement between us. And so this is something you want to include in your shareholders agreement, an obligation to notify the company if you enter an agreement to vote your shares a particular way. This way, the board of directors understands what's going on with the shareholders. The next is shareholders agreements, right? So it used to be that you could only have a shareholders agreement if you had 100 shareholders or less. That's removed. For the most part, that's not going to affect most companies. The provisions can pretty much take over whatever the Business Corporation Act says. So if the Business Corporation Act says that there's the shareholders are, directors are elected on an annual basis, we could say no, they're going to be elected every 2 years, right? Things of that nature. Except for things that are limited by public policy. And the old statute had a list of things that it deemed prevented by public policy. That list has been removed, and so now it's up to the courts to determine. So, good thing, bad thing, right? One of the things that we look at when we revise statutes is the idea is we want to take kind of this ambiguity and make it smaller. And then in some ways we made it smaller, but then we added some ambiguity as well. This being one of those.
I kind of think of that as the Lawyer Full Employment Act. You
Yeah.
know, instead of making it clearer, because there used to be a list of things you couldn't do, now it's up to the court on a case-by-case basis.
You're gonna lose your license of practice. You keep talking like that in public. We do want to put in a fee shifting provision in there so that nobody plays games. And then a really important piece that really now matches up with the LLC statute, and that is if we have a deadlock resolution provision, right? So deadlock is 50-50 shareholders. I want to turn left, Susan wants to turn right. We now can't do anything because we don't have an agreement on it. We have a deadlock. In the past, to resolve that, the only way we could resolve it was to go to the court and say, dissolve the company. Right? So that's kind of the nuclear option, right? Because goodwill, all the value of the company essentially goes away. Now the statute provides that if we have a shareholders agreement and that shareholders agreement contains a deadlock mechanism, some way to resolve that deadlock, the court is required to enforce what's in the shareholders agreement and can't move forward with the dissolution.
So the other thing to remember is, no contract is self-executing, right? I mean, the shareholders agreements or any contract you enter into, you're still involved in a lawsuit if you want to enforce it. So, I mean, it's really only as good as the people that you're doing business with.
Is the deadlock resolution mandatory? Does it have to be included in the shareholders agreement?
Oh, it doesn't have to be, but I would,
Should
yeah.
be, right, yeah.
Yeah, I would say that if it's not included in a shareholders agreement and the lawyer hasn't advised the client that it should be, then that lawyer has not done their job. Okay, so prevent judicial dissolution. You can request the appointment of a custodian or receiver, but you can also request a provisional director be appointed. It's allowed for less than all the shareholders. So effectively, if again, Nick, Susan, and I are shareholders, Susan and I can enter an agreement. Nick isn't bound by it, but Susan and I would be bound by that agreement. So that's also important. Certificated shares. So just let's talk about shareholders agreement in particular, right? Shareholders agreements are so important because what ends up happening is think of it as a prenuptial agreement, right? You're figuring out the way out when you're going into the agreement, into the relationship. And that's exactly what this is about. It's all about making sure that the business doesn't suffer if the owners have a disagreement or one of the owners wants to retire or is kind of done with what they're doing, right? And so there are things that we want to protect against. We want to protect against somebody showing up and saying, hey, I'm a shareholder. Well, how do we do that? Well, we could do it through the court, through evidence, but we can also make sure that every one of our shares is certificated. So the question is, did you get your share certificate, right? It's evidence of being a shareholder. We most certainly want to include in here the method of determining the value at different types of exit events. So if a shareholder is leaving, what are we looking at determining? Are we looking at determining the fair value, the fair market value, or a fractional interest, right? So fair value, which is used in the statute, is essentially the value of the equity multiplied by the percentage ownership. Now, in fair market value, we take into account the fact that a person has a minority interest in the company, so they can't control the company, and that their interest is not marketable. And by virtue of that, we're deducting value out of the shares or the value of their equity in the business. Fair value does not allow us to take that into account. So the statute is focused on fair value, and we probably want to be focused on fair market value. Now, of course, the benefit of a shareholders agreement is that it precludes the minority, if drafted properly, that's the key, if drafted properly, precludes the minority from being taken advantage of by the majority. Because now we're setting up what that relationship is going in. And to some extent, it also protects the majority from being taken advantage of by the minority. Because there are certain instances where the minority shareholders can kind of veto action. Limited, but they can do it. Okay? And then we can have director removal, right? Remember that provision that allows us to remove directors? Well, we can include a definition of irreparable harm in our shareholders agreement and seek to enforce the shareholders agreement. So we don't have to worry about whether a court agrees with us that the corporation is suffering irreparable harm. We can put it in our shareholders agreement. So as you can probably tell, I'm a fan of shareholders agreements. Right? Okay. So there was a whole slew of changes to these areas around mergers and share exchanges and conversions and domestication and things of that nature. The one that we use on a regular basis is conversion, because as I said before, people will file an LLC and then they'll come in and we'll say, okay, well, you really needed to be a corporation, or vice versa, and so we'll do a conversion. But if you're doing any of these transactions, just call us and we'll walk you through it, because this is really in-depth and detailed. Any questions?
Yeah, and I was wondering, if there's an issue, and these things have not been done, does that collapse the corporation in any way? Does that dissolve it? I mean,
No,
Okay.
no, it won't dissolve it. I mean, the dissolution would only be, if you didn't have a shareholders agreement, you didn't have bylaws, you had to have articles, right? And so the statute gives us the default. And so we then look to the statute, when would there be a dissolution, under what circumstances, that kind of thing.
so it just gives you more work if that's not done.
Well, yeah, absolutely, right? If there's a dispute, yes,
Cheaper to do it up front.
it is way cheaper to do it up front.
Yeah, so one of the benefits of a corporation is you don't have personal liability. So in an LLC, the LLC statute doesn't require a lot, you don't even have to have a written operating agreement, which would be a big mistake if you're a multi-member LLC. But in a corporation, by statute, you're required to have articles and bylaws,
Right.
and you're required to keep the corporate formalities. You have to keep your assets separate from the corporation, and if you don't do all those things, then arguably in a dispute contest, the court could say, well, it wasn't really a corporation, it's just you who were liable.
That's what, yeah, that's what I mean, whether they determined by all the factors and all the acts or anything, that it was never really established correctly.
So in Florida, I don't know of a case where they've pierced the corporate veil absent fraud.
Okay.
But if you're arguably committing fraud and you're not keeping up the corporate formalities, you've got a real problem.
I would add one more to that, though, is when you're treating the corporation as personal asset. So if you're paying your mortgage and you're paying your electric bill and you know, there's no distinction between you and the corporation, then you're likely to have that piercing issue. Especially if you got creditors that you didn't pay, yeah, that's gonna come up. No, any other questions? Yes.
I have a question. So I understand, like, reviewing and making sure that we update our documents, our corporate documents. We have had to provide some of those documents to, like, our franchise lenders. Are we required also to make sure that we go back and provide updated agreements to our
It's gonna depend on the franchise agreement itself, as to whether or not you have to do that. Usually franchise agreements are concerned with transfers, not necessarily with that, but you'd have to look to the actual language of it. And yeah, so. Coffee.
There's three types of shares, if you want to think about it. There's the authorized capital, there's the issued shares, and then there's another concept called fully diluted capitalization. So what are authorized shares? That's the number in your articles of incorporation. It has to be in the articles of incorporation, and there's that you can't ever issue more shares than the authorized capital in the articles of incorporation. And only the board of directors can amend the articles of incorporation unless, under certain circumstances, the shareholders agreement does away with the board of directors. But you can never issue more shares than the authorized capital. Now, outstanding, so let's say there's 1,000 shares authorized. Now, and if Nick and Ed and I are partners or shareholders in the business, maybe we each have 100 shares. So there's 700 more shares that can be issued, authorized capital maximum of 1,000. And we each own a third of the company. So it's not a percentage of the authorized shares, it's really a percentage of the outstanding shares. This is unusual. Florida law, so you have common stock or preferred stock. If the stock has a distribution preference on liquidation, if you're selling the company, you can't call it common stock. And if it doesn't have a distribution preference, can't call shares without distribution preference preferred stock. I wanted to talk a little bit about one reason that they passed this new act is there's a lot of law in Delaware, Nevada, New York, those states. And lots of times, if we're raising capital from investors out of state and their lawyers are coming into Florida, and they're like, well, Florida doesn't have a lot of corporate courts interpreting the corporate statutes. So now our statute is based on Delaware law, it's based on the Model Act, and the answer to those other lawyers, whether they're in Georgia or California, whatever, is Florida is now very similar to the statutes in those states, and we can use the law in those states to interpret Florida law, so it makes more sense. One change to the law, Ed talked about it a little bit, is now when you have authorized capital, the provisions of those shares, the provisions for preferred stock can be based on extrinsic events. Or so, for example, preferred stock, you have dividends for preferred stock. Used to be the dividends had to be a particular percentage, let's say 8% or 5% or whatever. Now it could be based on interest rates as they change, prime rate as it changes from time to time. Fractional shares are less than one full share. So this often comes up in stock splits or recapitalizations or those kinds of things. The other place it comes up is if somebody's investing money in your business. Maybe so typically they tell you how much money they're going to invest, not how many shares they're going to buy. So they may end up having less than one full share. That's fine. In a transaction, so one way that majority shareholders can get rid of a minority shareholder is to reverse stock split them out so they end up with a fractional share. And under Florida law, you can then cash them out by paying the fair value of those shares. There used to be a conclusive presumption that the board could determine what fair value was. No longer. They changed the law now, and the board has to exercise its business judgment and has to be fair, more or less, in good faith towards the person that they're cashing out. Blank check preferred shares are, this is a way typically used when you're raising capital, where, again, if you have a set number of shares in the Articles of Incorporation, you can only issue that many shares. If you're going to issue preferred stock, you can set forth the terms of that preferred stock in the Articles of Incorporation. But a fast way to do it, and you need shareholder approval to amend the Articles of Incorporation. But if you have what they call blank check preferred stock, you say, okay, I'm going to issue up to maybe 5 million shares of preferred stock, and later when I'm going to do the transaction, we'll set forth the terms of that preferred shares, like the dividend rate or when it could be repurchased. And that's what blank check preferred shares are. Appraisal rights. So if you do a major corporate transaction, maybe the sale of substantially all the assets or a merger, your shareholders have the right to dissent from that transaction, and instead of getting whatever consideration they would get, maybe it's the stock in a public company that's buying your company or the stock in a private company, they can dissent, they can object, and it's a lawsuit, right? They got to file with the court after you've complied with all the provisions and say, I don't want whatever consideration you're going to give me, I really want the fair value of those shares. And fair value is determined now, under Florida law. The new change is it's without regard to discounts for marketability or for minority ownership. And it's basically what the valuation of that business would be under generally accepted valuation principles. And interestingly enough, it's not the same as fair market value. Ed was touching on that a little bit. So fair market value, the way I think about it is, it's what a willing buyer and a willing seller would pay in the transaction. But fair value is a slightly different concept. It's really what the business is worth based on customary valuation principles. Even if your shareholders, sometimes they have non-voting shares, you may have a silent partner. They're also entitled to appraisal rights under Florida law now. And again, if you exercise your appraisal rights, you're not entitled to any other rights as a shareholder of the corporation. So there are any number of things you can eliminate by shareholders agreement. Ned talked about shareholders agreements a little bit, actually quite a bit. And there's two kinds of shareholders agreements. There's an agreement where the three of us are shareholders, but only Nick and I enter into a shareholders agreement. That binds me and Nick to comply with that agreement. But there's a separate statute, this 0732, where if you comply with all the provisions of the statute, you can bind all of the shareholders. And used to say that one thing you couldn't do, so you can't include a provision. Now you can include all kinds of provisions in a shareholders agreement that will bind all the shareholders, including eliminating the board of directors. But it used to say you couldn't do anything that was against public policy, including eliminating appraisal rights. Well, this is an example where they made the statute less clear instead of more clear. And so now it doesn't say anymore the things that you can't do in a shareholders agreement, including eliminating appraisal rights. So it's potentially against public policy to eliminate appraisal rights, and I guess we'll find out when they start litigating those cases.
One of the things about appraisal rights is that you can vote in favor of the transaction when you do it. So one of the things that I've done in agreements in the past where this issue's come up is I've required, it's called a drag-along provision, where if there's a majority of the owners that want to do the deal, and then we require the minority to vote in favor of the deal. I think that's a workaround. I would never say that it's 100% sure, but it might be a workaround.
So we put that in our shareholders agreements all the time. I've never had a lawyer buying the business that wanted to rely on that, and I've never actually seen anybody rely on it. And to the point that there's two different kinds of shareholders agreements, I would argue that if it's a shareholders agreement among particular shareholders and they agree to waive their appraisal rights and to go along with whatever the majority shareholders are doing, I think that it is enforceable against them. But if you're trying to do it on an agreement where you're binding people that aren't party to that shareholders agreement, that's where this comes up, and certainly there's an argument that's against public policy, but we don't know yet.
So the big takeaways, obviously, review and really have some discussion about your organizational documents. Absolutely positively, if you have a multi-owner corporation, it should have a shareholders agreement. If that's the only takeaway you have, that's the most important, it really is. We should update all of the corporate documents, the governance, all of that to be in compliance. Again, we want to make sure that we protect that corporate veil, and that if we have any situation where there's outside creditors, that you have the maximum protection possible. Obviously, we've got to work with attorneys that are just focused on this particular area, the business law area. And so what we've done is basically set up two packages. We work on a fixed price basis when possible, most of the time. And so, really review those organizational documents. We'll take a look at everything. We'll determine, what's not compliant, what is, where do we need to be. We'll make the suggestions, and then if the client wants the suggestions, we'll actually put those into the documents. We'll file the amended articles of incorporation. What we've done is gone from separating out the costs and our fees to just putting it all together. It's much, much easier, so the filing fees are included. And then we have a corporate veil program that I'm going to talk about in a minute. But basically for single entity, normally it's 13, so we're doing it for $9.99. And then for multi-owner entities, $59, and we'll do it for $54. And so really this is a comprehensive start to finish approach for business owners to make sure that everything is compliant. So you don't get surprised at a later point in time, and usually that's a nasty surprise. And so
one question that came up is, are husbands and wives considered to be single owner entities?
So for purposes of our package, or for purposes yeah, for purposes of our package, they can be a single owner entity, yes. For purposes of tax law, that may not be the case. Yes. Okay, so we have the corporate. We basically adopted now a corporate veil program that we're rolling out. So what happened? What happened is people did not follow their corporate procedures. They got administratively dissolved. They didn't do their annual meeting minutes. They had issues come up in the business, and they didn't call us and say, hey, I got this issue, I really need some advice. So we want to make it as easy as possible for them to make sure that the annual report is filed, that all of the things that they need to do are done. And so we basically put together this program, and realistically, we need to look at kind of this or this program because it includes the in-office meetings to do the updates, it includes the filing of the annual reports, and it includes us acting as the registered agent, right? So when service is had, and it's interesting, sometimes you'll see that somebody will have a registered agent that'll no longer be a part of the company. And so service is made on the registered agent, but the registered agent doesn't provide that service to the corporation, and then they get default judgment entered against them. So we'll act as that and essentially make sure that you get the documentation that you need. So those are our programs. You have this material in your packet, and on the back is the sign-up form for this. You know, if you have a client or you yourself think this is something you want to do, just sign up and give it to us, and we'll definitely handle that. Any questions? Yes.
Corporate compliance survey. I'm not as familiar with that. What is?
So what we're basically doing is checking on, okay, have you done your annual minutes? What has changed? We're really, really getting into where were you and where are you now? So we make sure that everything follows and that there's no disconnect between, yeah, we think we're doing this now and we're over here, right? Things that would, somebody says, oh, well, I'm going to add a key employee as an owner of my business. Okay, well, now we really got to have a discussion about it. So those types of things. Any other questions?
Husband and wife, they own all the stock. What are the greatest concerns they should have going forward with the changes?
Truly, well, first off, we have to understand how they own the stock. Do they own the stock as husband and wife? Or does one own one number of shares and another own a number of shares? And then, so that's the status one? Yeah. Okay, so there is two true shareholders in that corporation. Mm-hmm. And we do need to figure out what is going to be the process of undoing that. Because, I mean, if for kicks and giggles, I'll tell you a quick story, right? We had a couple, actually the man came to us, it was a husband and wife, the man came to us and said, hey, what can I do? What happened is they formed an LLC and they wanted to be MWBE certified, so Minority Women-Owned Business Enterprise, and so they could get some government contracts. Well, everything was going great, they started to have marital problems, and so then they separated. And the wife, who owned a majority of the interest, fired the husband. And because you're an owner of an LLC or a corporation doesn't mean you're automatically an employee of that owner, that corporation, or that LLC. And so those are the kinds of issues that we talk about. We do a partnership design session, and we have 21 different things that we go through. Now, it would be less for a husband and wife because it would probably focus more around the issue of when one dies, what do we want to have happen? And then we definitely need to tie that in with the estate plan. But that's an example. Good. Okay. Any other questions? Thank you very much for coming. I really appreciate it.
Thank you.